I'm going to start with automated decision making, or ADM as we like to call it. So this is about decisions made about you that have significant effects on you. At least it's decisions that are made solely by automated processing. And we felt there were a number of issues with how this was working in practice. We talked to stakeholders who were finding the regime a little difficult to navigate. And we thought that with the growing use of emerging technology, it's likely that ADM is going to be on the increase. So we thought this was a good area where we could see, is there any potential for some reform or at least some fine-tuning? So I'm going to just set out for each of these provisions what I think the top 3 key aspects or changes are. So for ADM, the first key one is that we are clarifying what solely automated decision-making means. And by that, we don't just mean it's decisions without any human involvement. We mean decisions without any meaningful human involvement. And this is aimed at stopping a practice whereby some controllers may well be thinking, right, the rules don't apply to us because there's a human somewhere in the loop. So we are clarifying here that this involvement has to be meaningful. The second key aspect is that we are taking powers for the Secretary of State to further be able to specify these terms if this becomes necessary in the future. So we may well need to be saying, these circumstances are meaningful, these circumstances are not meaningful, this is a significant decision, this is not. So this is about, again, being able to ensure that our regime is able to adapt to possibly new uses of ADM, automated decision-making in the future, and maybe societal changes as well about what kind of significant decisions could be being made about us. And then the third key point about ADM that I want to mention, and possibly I think the most significant, is that we are broadening the circumstances for ADM. In other words, we are allowing that this can now happen under the legitimate interest ground. And the government was keen to do this to be able to take, so controllers could take full advantage of emerging technologies. But I think it's also important to note that the restrictions on sensitive data still remain here. And we do have various safeguards in this provision itself, as well as beyond it in the wider Data Protection Act. So just to summarise in terms of compliance for ADM, what the important things to know there are is I think it's good for controllers to be able to see, does this provide any more opportunities perhaps to do ADM in a way that maybe might not have looked at before, but also it's very important to be reviewing just what exactly does meaningful human involvement mean in your particular area, and is it compliant with the new provision? So that was the first box I wanted to look at. I'm going to move on to a second area that I think is very important, international transfers. Now, this is becoming more and more important every day. We're seeing that international transfers underpin commercial transactions, international trade, financial institutions. I've been working on research provisions, and it was quite surprising to find out just how much research depends on international cooperation. So the international transfer regime is very important to us, and that's why we made it one of our priority areas for reform, particularly also as we were aware that there were various areas of uncertainty that had been emerging lately in this domain. So what are the top 3 changes or aspects to this reform? Firstly, we are redefining the data protection test. That is the test that our Secretary of State applies when deciding whether another country or territory or an organisation is indeed adequate. So actually the word adequate is out. It's adequate is inadequate. Instead, the test is, does this third country offer a level of protection that is materially lower than the UK, in which case we cannot make adequacy regulations there for that country. And the provision also clarifies that the Secretary of State can consider economic factors and political factors as well, but the overall data protection test, is the level materially lower or not, that is paramount and it must be met. The second aspect to international transfers reform is clarifying what happens for alternative transfer mechanisms, so what exporters may use when there's no adequacy decision. And in this case, we're clarifying what are the obligations here. Namely, that data exporters that are using ATMs must take reasonable and proportionate steps to ensure that the level of protection is not materially lower due to this transfer. And then lastly, on international transfers, we are taking a power, again this is part of our future proofing, so that the Secretary of State can recognise new future mechanisms of transfers for the safe protection of UK data going outside the country. So with this power, the Secretary of State might be able to create a whole new mechanism themselves, or they might be able to recognise a mechanism that's arisen in another country, another jurisdiction due to emerging trends. So this will be about ensuring that our safeguards for international transfers can continue to evolve. In terms of what this area means for compliance, I think it's really important to note that the level of protection, obviously the existing standard is not being lowered. And the Act also clarifies that if you have an existing transfer mechanism that meets the current standards, then you can continue to rely on it without any further assessment. But what we're aiming to do with these provisions really is looking forward to the future, and we want to be able to ensure that it has the best chance of being future-proof, given the general sort of uncertainty there's been in this area, and also provide more clarity for controllers who may be looking in the future to create new transfers, to create new alternative transfer mechanisms. So that was a whistle-stop tour through two topics. I'm now going to turn on to the third topic, which is further processing. And this is, again, a model example of our work aiming to try to find out where can we clarify without actually overhauling. And further processing was an area where we found, when we looked into it, there was a lot of uncertainty. There was uncertainty across various different aspects of it the more we dug in. And so the main key changes in this area, firstly and most importantly, we've clearly delineated all the circumstances where you can do further processing, i.e. when there's a change of purpose, when can you do that new processing. We were inspired by Article 6, the look of it. It's very clean, neat, 6 legal bases, so we wanted to replicate that in a brand new article that's purely for for allowing further processing when there's a change of purpose. So it sets out all the circumstances from when you assess it being compatible to when you are processing purely to comply with the UK GDPR, such as conducting pseudonymisation. The second key change for further processing is looking at when are you further processing? So one thing we found out when we researched this was there was a bit of doubt as to what happens when there's a change of controller. So if one controller discloses to another, does the new controller have to do the compatibility assessment? And if so, how? How do they find out what the old purposes are, especially if there's a really long chain of controllers going all the way back? So we've clarified there. The answer is no. They don't have to do that. And this is in line with ICO views, ICO guidance. So we're clarifying that basically new controller means new processing as far as the purpose limitation principle is concerned. And we hope that that will give some badly needed clarity to this area. And then very lastly, on further processing, we are clarifying what does it mean in relation to other key aspects, other obligations of the GDPR, namely lawfulness and the requirements around consent. On lawfulness, we found there was sometimes some confusion with some controllers thinking, can we still use the old lawful basis for further processing, even if it's maybe invalid? Our answer is no, you have to make sure always that it is a valid lawful basis, whether it's old processing, whether it's further processing. Even doing the compatibility test, you've still got to make sure that you've got a legal basis that's working for the new further processing. And we also wanted to clarify what happens with consent. So if you've got consent from a data subject for purpose X, but you want to change to purpose Y, can you do that according to the other further processing rules, or does the data subject's consent override that, especially in regards to, say, fairness? And we've clarified that, in general, the answer is no, you can't change purpose, but there are some limited exceptions, if you get fresh consent, obviously, and if you meet any of the limited public interest exceptions. But overall, we are making it explicit that there's a general prohibition on changing the purpose when you got consent from the data subject for one particular purpose. I mean, in terms of compliance, we generally see these provisions more as clarifying, not as permissive. We think putting all the routes in one place rather than where they're currently spread out, say in the recitals, the schedules, sometimes different legislation, we think this will help controllers find more permissions where they exist. But given the current confusion that does exist around this area, we would recommend that controllers pay very close attention to what we're saying about the requirement for lawful basis and around when you collected data on consent, so under Article 6.1a. And then very lastly, because I know this is a lot of detail, I'm going to briefly touch on the research provisions, and this is one that was a battleground in the House of Lords up until really the last stages. It surprised us very much because we saw these proposals as largely clarifying, and we thought that they were a good illustration of our overall approach of trying to fine-tune rather than overhaul. But very briefly, the 3 key points that illustrate this. Point number 1, definition of scientific research. This is intended to capture the spirit of the recitals. We wanted to make this key information more prominent, so we introduced a reasonableness test. And this basically says, would a reasonable person describe this sort of particular topic as scientific research? Yes or no? And we provide potential examples, also mostly from recitals or ICO guidance, but those are all subject to the reasonableness test. Secondly, we've elevated the possibility for broad consent to an area for scientific research into the operative text. Again, this has already existed, but we thought we wanted to give it greater prominence and awareness. Consent isn't often used in research, but when it is, it can be really helpful for researchers to be able to get consent to a broad area rather than a specific narrow purpose, especially when they might not know actually what that purpose is at the start of the study. And very lastly, the third point for research, we've introduced a new exemption for the transparency requirements when there's a change of purpose. This is very narrow. It's aimed when there's maybe longitudinal neurological studies and the controller, the researcher, wants to evolve the study sort of to a new direction, but they've lost contact with the data subject, they're not able, it would be a disproportionate effort to get back into contact with them. So those are some very small changes for research. In terms of compliance, if you're already, if you're scientific research before the bill, you're scientific research after with the Act, and if you weren't scientific research before the bill, it's not scientific research after the Act either. But we hope the effect of these small changes is to provide more clarity and confidence for researchers. Small changes that might still make a big difference.